Wallace.
The Criminal Law Sexual Offences Amendment Bill 2018 is an example of a broken legislative system as far as we are concerned, and something that we as legislators should be extremely concerned about. It's the second time that a piece of flawed legislation proposed by an independent Alliance TD has been allowed progress through the Department of Justice. I hardly need to remind everyone of the disaster that the Judicial Appointments Bill amounts to. It appears that Fine Gael, historically the party of law and order, are prepared to allow their coalition partners propose flawed legislation in order to maintain their support. The main goal of the bill seeks to impose presumptive minimum sentences for sexual offenders who have been convicted of sex offences and received a sentence of at least 5 years and who go on to commit another sexual offence within a further 10. This bill appears to have been proposed based on the concerns of a few particular constituents of the Minister, and this amendment, which will remove Section 4 and 5 of the bill, will render the main goal of the bill null and void. In fact, the Minister admitted that the genesis of the bill came from his constituents when he told the Justice Committee that I have met victims and the purpose of bringing forward this legislation is based on the evidence put in front of me by these people. But this is not really how legislation should be drafted, in our opinion, to appease the concern of the constituents. I'm not saying that these constituents do not have valid concerns, and we should listen to our constituents, but drafting primary legislation on concerns alone is not the answer. Legislation should be based on multiple issues: empirical evidence, discussions with stakeholders, in this case the courts, the prison service, victims, families of victims, offenders, counsellors, experts and whatever. Just to discuss some of the reasons why we are proposing this amendment, Section 4 appears to be based on two falsehoods. Firstly, that there is a high rate of recidivism by sexual offenders. In 2013, the Irish Prison Service conducted a study on recidivism which found that the offence groups with the lowest rate for reoffending were homicide at 26.2%, followed by sexual offences at 28.2%. While it's obvious that the rate of reoffending would be low in cases of homicide, the reoffending rate for a sexual offender is also low compared with a crime like burglary, where the reoffending rate stands at 79.5%. How the Department of Justice, in drafting this bill, conducted any up-to-date studies on recidivism rates of sexual offenders? I wonder, have they? Second, that incarceration stops sexual offenders reoffending is a second basis of the section which we disagree with. A US study from 2007 of 627 sexual offenders found that there was no evidence that the relationship between incarceration and recidivism was confounded or moderated by risk or the length of incarceration, and that sentencing sexual offenders in terms of incarceration appears to have little, if any, impact on sexual and violent recidivism following release. Have the Department of Justice conducted similar studies on sexual offenders in Ireland? I'm not sure if you have done this, but similar to the recidivism rate of sexual offenders, it's worrying that it appears that the Department of Justice has not done any analysis. Finally, as mad as this sounds, Section 4 will probably never be applied in the way that the Minister hopes, as it gives the judiciary a get-out clause, which I can only assume has been inserted at the behest of somebody in the AG's office, as they probably share the same concerns we have voiced. The get-out clause states that subsection 1 shall not apply where the court is satisfied that it would be disproportionate in all the circumstances of the case to specify as the minimum term of imprisonment to be served by the person concerned the term of imprisonment referred to in that subsection in respect of the subsequent offence. An identical get-out clause was included in Section 5 of the Criminal Justice Act 1999, which sought to impose a mandatory 10-year sentence on anybody found guilty of possession of drugs valued above $13,000. The first thing the judiciary did when sentencing under this Act was to go straight to the subsection, which allowed them to use their discretion, and this has resulted in less than 10% of the convictions under this legislation amounting to the full 10-year sentence. Instead of this bill, we think the government would be better placed proposing legislation that makes it mandatory for sexual offenders to do therapy while in prison. At the moment, there is currently a programme called Building Better Lives programme. However, although it is made available to all sexual offenders in Ireland, it is voluntary and it requires participants to admit the offence they cause and the harm done to victims before they can take part. Figures obtained by RTE's John Burke before Christmas show that the number of sex offenders who are being released from prison without having undergone the programme has increased. Out of 135 sex offenders who will be released this year, as few as 17 have taken part in the Building Better Lives programme. There are approximately 450 sex offenders currently in Irish prisons at any one time, yet it appears that the numbers taking part in this programme are dropping year on year. In 2015, in a PQ reply, former Minister Francis Fitzgerald told the House that 136 sexual offenders were released from custody in 2014, and 29 participated in the Building for Life programme, and so there's actually been a decrease since then. The drop is worrying, particularly as the figures show that those who complete the BBL programme are less likely to re-offend. The head of the Irish Prison Service Psychology Service, Dr. Emma Black, told RTE that the recidivism rate for those treated under the BBL programme was much lower than those untreated. The recidivism rate for people who have undergone the treatment over 15 years is about 5.4%, compared with those untreated at about 19.6%, she said. This is an amazing statistic, and it begs the question why the Department do not consider making the BBL programme mandatory. Minister Flanagan is on the record as saying that he is very keen to work closely with Irish Prison Service on the issue. I understand that certain offenders refuse to admit their crimes. However, Dr. Black stated that the Irish Prison Service was now considering introducing a specialised treatment programme aimed specifically at so-called categorical deniers who refuse to admit the sexual offence, the sexual abuse they engaged in, or that it was harmful to their victims, and a business case has been put to the Department of Justice for additional resources on this issue. If the Minister Flanagan and his department want to properly address the issues surrounding sexual offences and recidivism, they should withdraw this bill and instead examine making programmes like the Building Better Lives mandatory for sexual offenders. As we know from the US study, incarceration alone does not stop recidivism. Thank you very much.